The U.S. Supreme Court took up a racially and politically charged case from Louisiana today that tests the Voting Rights Act of 1965. The issue is whether congressional districts can be created to protect the voting rights of minorities without discriminating against voters of other races. Capitol Hill correspondent Erik Rosales joins us from outside the U.S. Supreme Court with the latest. Erik.
Well, good evening, Veronica. Right now, Section 2 of that Voting Rights Act tries to keep congressional maps passed by state legislators from diluting the votes of minorities by either packing them all into one district or spreading them out into too many districts where they don't even have an impact. But the state of Louisiana argues that those redistricting protections are both impossible to follow and unconstitutional.
The minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district, and a district is reasonably configured if it comports with traditional districting criteria.
What you can't have is merely just showing that a Republican legislature favored Republicans, with whether or not they're white or black. And there's just no reason in the world to think that the Louisiana legislature would have done anything different in this case if every black Democrat in Louisiana was a white Democrat.
In Louisiana, the African American community makes up roughly a third of the population and tends to support Democrats. The state has 6 seats in the U.S. House. Janae Nelson, a lawyer for the NAACP, said siding with Louisiana's request would throw maps across the country into chaos.
Were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is black was elected from a VRA opportunity district.
Some of the conservative justices voiced concern about the application of Section 2 in the Voting Rights Act, in this case to create a second black majority district. The liberal justices emphasized how gutting Section 2 would sharply change precedent.
If you can use race in some ways that are positive, why can't you use it to remedy something in some ways?
Your Honor, my friends on the other side walked into the Middle District of Louisiana. May I finish very briefly? Yes. Walked into the Middle District of Louisiana and demanded a majority black district. What's the purpose of that kind of district? The avowed purpose of drawing a majority black district is to diminish the voting strength of some racial groups and augment the voting strength of others.
After several hours of arguments, attorneys representing the state of Louisiana said that they simply want clarity on how to proceed in the future. Now, the Supreme Court is expected to rule by the end of June, which could have a major impact on the upcoming 2026 election. Now, Republicans currently hold a slim majority in the U.S. House, and a decision invalidating Section 2 could benefit them immensely. Democrats affiliated groups say that such a decision could allow Republicans to reconfigure and pick up as many as 19 House districts across the country in their favor. Outside the U.S. Supreme Court, Erik Rosales, EWTN News Nightly.